variety of thought on the issue of housing levy. I did advise Kenyans and also talk to the president and did tell him that housing is a private good. In economics, we have three types of goods. We have private good, and private good should be left to individuals to get upon themselves. Then we have the public goods, which are goods like the roads, which should be provided by the government. And then we have the merit goods, where a government should create an enabling environment for these goods to be achieved, for these goods to be transacted. And these are goods like healthcare and also education. But this being a private good, and today, and it is very, very coincidental that I'm also in court today, and the reason why I was arrested, brought here in court, is because of the housing levy, fighting for Kenyans, so that this housing levy would be declared null and void. And indeed, true to my words, and this proves my innocence, true to my words, today the courts have agreed that the housing levy that was pegged on the Kenyans, put on the shoulders of Kenyans, indeed is unconstitutional. And I want to really thank the judiciary for that. And I want to say that the government was stealing from Kenyans. The government was defrauding the hard-earned money that belonged to Kenyans. And I want to say that this is a type of theft called theft by pen. And I want to urge Kenyans to go to Statehouse and get their monies from Statehouse. It doesn't matter where this money will be gotten from, but Kenyans should rush to Statehouse now that the decision is still hot. We strike while the iron is still hot. And you know very well, my brother, that right now people are suffering. People have really paid for this housing levy. They've been taxed, they've been overtaxed, they've been used, they've been misused. And I can tell you that Kenyans are sniffing the blood of revolution. Let them go to Statehouse and get their monies from there. The idea of the postponement of this to take effect from January, I don't think it is a right idea, because already in the wisdom of the judiciary, they've seen that this thing is unconstitutional. So we can't say that it is constitutional now and it will be unconstitutional from January. It is unconstitutional ab initio, from the beginning. So my brother, I want to say that Kenyans, we need to go to Statehouse and get our monies from there. Thank you.
Decision by the court to grant a stay, especially for 45 days, and on the strength of an application, an oral application done by Parliament, that they also intend to have a period within which they can try and validate the regulation to support the housing fund, in our view, is highly irregular and unfortunate, and takes away what the court has just given in terms of making the right finding. As we have always argued, that the law is unconstitutional because it lacks a legislative framework. So what we view this decision is an attempt to give the government an opportunity and enough time to be able to put its house in order, to be able to enact the legislation that then is going to be the foundation for the housing fund, for the affordable housing levy, and also enable the government to collect money that it was collecting without a legal basis, and notwithstanding the fact that the court has found that to be unconstitutional. So not only was that unconstitutional, but the collection of the money by the Kenya Revenue Authority was also found to be contrary to the law. So there are two wrongs that have been given a new lease of life by the decision that the court has given. This is a radical departure from what other courts have done when it comes to assessing and considering the question of whether or not to grant a stay after a decision has been made. It would have been in order that the application is formally filed so that parties have the opportunity to respond and for the court to appreciate the magnitude of the decision that has been rendered. So for the court to give those kind of orders and to have them stay and valid for a period up to 10th of January 2024 is to actually render any proceedings that are going to be held in the Court of Appeal as moot and academic, because already the court has granted far reaching and unusual orders of stay of execution. So in a sense, the court has given with one hand and taken with the other, and it looks like except for the fact that the arguments that have been presented in support of the case were weak, it looks like initially the court was of the mind that it needs to find a way to sustain the housing levy, because you cannot take it that they had any other intention other than to find a way to keep this law, which is clearly unconstitutional and which clearly the entire country is aggrieved against, and conduct themselves in the manner in which they have conducted themselves.
All the same, respondents say they're going to the Court of Appeal. They're going to file immediately.